Let's look at the state's response to the recusal motions. I feel like this was very lazy, but we're going to read it anyway. This is the state's response to the defendant's motion to recuse Judge Earl Glanville in the trial above. And this is even though this is like an 81-page document fully, their motion, their response is only like 9 pages, so we don't have to read every single word, but we can read what I feel is the important parts. Midway, let's read the intro. Midway through the months-long trial, defendant Jeffrey Williams and defendant Diamante Kendrick have each filed a motion to recuse Judge Glanville, and defendants have filed supplements to the motions. The state recognizes that Chief Glanville has reassigned the motion and that has been properly assigned to this honorable court, but the state respectfully submits that at the time of reassignment, Glanville did not make the 3 requisite determinations, and he pretty much passed it on to the next court. Okay. Let's see. As set forth, though defendants, as set forth below, though defendants' motions and supplement are in part timely, and the affidavits in support of defendants' motions and supplement are in part legally sufficient, none of the facts set forth in the defendant's affidavits, even if assumed to be true, would authorize recusal. Now, this is the interesting part here. Attorney Love said, even if it was all true, it wouldn't even authorize recusal. That's very strange, and that's not true. Defendant's motion and supplement, therefore, should both be denied. Factual background. This is what they consider to be the facts. The calling of state's witness Kenneth Copeland on June 7th. On June 6th, in response to an inquiry from counsel from the defendants in the case, the state announced that Kenneth Copeland would be the next witness and would be called to testify on this date. After the announcement, the state received an email from John Melnick claiming to represent Copeland and instructed the state to cease communication with Copeland and that Copeland would be asserting his Fifth Amendment. Now, remember, once again, guys, the state said, and the judge said a bunch of times, we didn't know he was going to plead the Fifth. We don't know where this is coming from. We thought he was going to testify. There is documented proof that they knew he was going to plead the Fifth, and they even say it in this recusal response right here, that Copeland told them ahead of time, I'm pleading the Fifth. Copeland said a bunch of times in that private meeting, I told y'all I was going to plead the Fifth. So I don't get why they're not revisiting that whole dirty tactic of putting a witness on the stand that you know is going to plead the Fifth. I don't get why that's not able to be revisited. That's a very crazy thing to me. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectively by Brian Steele and Max Shard, Melnick copied Brian Steele and Max Shard on his communication with the state regarding Copeland's intent not to testify. In preparation for trial, Deputy District Attorney Hilton, along with her investigator, had met with Copeland on multiple occasions, and at no time did Copeland state an intention to plead the Fifth or say he was represented by Melnick. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with them, and then pursuant to 24-507, they put in that immunity order, right? So we can scroll down a little bit. After court was called to order, Melnick appeared to court, informed the court that Kenneth Copeland would be asserting a Fifth Amendment privilege against self-incrimination in the presence of each defendant currently on trial and in each of their representative, this. I want to get to the actual important part because they just saying anything right here. I'm not going to lie to y'all. The state is just saying whatever they feel like saying. Let me see if... Okay, here, this is... hold on. The June 10th meeting regarding contempt proceedings initiated against Kenneth Copeland upon motion of the state, attended by counsel for Copeland, attorneys for the state, Kenneth Copeland, and Glanville. On Monday morning, prior to the start of court, the state requested from the court an in-chamber meeting with counsel for Copeland, Kenneth Copeland, the court, and attorney for the state to discuss the contempt proceedings initiated against Mr. Copeland upon the state's motion. I do want to say again, it is interesting. I've seen a lot of people point it out. Love made sure she was in the meeting earlier in the day when it was just Bumpus. It was the court reporter. It was the couple security, Glanville and her. She made sure she was not in the meeting that had Kenneth Copeland directly in it. She made sure of that because if somebody has to get kicked off the case for having a meeting like that, they want to make sure that it's Hilton and not the lead attorney, Attorney Love. She knew that was wrong, like I said, and we talked about this before. Attorney Love was a judge in Middle Georgia. She knows these laws. She knew what she was doing, right? So cold-blooded. She set Hilton up for the okie doke. The court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. Present during the meeting were CDDA Love, Chief Deputy District Attorney Love, Attorney Bumpus, investigators for the state, and the Honorable Glanville, and later Kenneth Copeland and DDA Hilton, Deputy District Attorney Hilton. Matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed including topics Copeland's rights and representation as it relates to the proceeding, Mr. Copeland's obligation under OCGA 24-5-507, and answers to questions posed by Copeland regarding the matters related to this statute, such as the distinction between purging himself of contempt as addressed and perjury, with the exception of the times where Copeland was afforded the opportunity to speak to her alone. Okay. Brian Steele's defiance of the court. After meeting regarding Copeland's contempt and obligations under this, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at the chief at Glanville accusations of misconduct. Most disturbingly, after accusing the court of an illegal activity, Mr. Steele repeatedly disobeyed Glanville's commands to reveal Mr. Steele's source of information regarding in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Steele in contempt. After defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed a motion to supplement. Now, just because a judge tells you to do something does not mean you have to do it unless it is a lawful order. Glanville telling Brian Steele that he needs to tell him something that somebody else, or tell him who told him something, I don't know what law supports that. And Glanville never cited any law. So that's why his whole thing fell apart when he said, I'm going to hold you in criminal contempt. And the whole thing just fell apart. Like, what was he doing? That's not a lawful order. Judge can't just tell you to do anything. Any old random thing, right? Argument and citation of authority. No fact set forth in defendant's motion of supplement authorizes the recusal of Judge Glanville. To warrant disqualification of a judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what judge learned from his participation in the case. Okay. All right, I'm going to keep reading. Emphasis added is funny. There is a presumption that a trial judge acting as a public official faithfully and lawfully performs their duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Here, with the exception of the defendant Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for not being prepared, defendant's motions and the supplements are based entirely on the defendant's assertions regarding June 10th meeting, regarding the contempt proceeding against Copeland and actions taken by Glanville after Steele defiantly refused to comply with the court's repeated requests to provide the court information. Here's the important part also. Excuse me, I got to read this. Sorry. Georgia Code of Judicial Conduct 2.9, which we have read extensively, guys, right? Regarding ex parte communications provides that the judges shall accord every person who has a legal interest in a proceeding or a person's lawyer the right to be heard according to law. However, no defendant on trial in this case has had any legal interest in or standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on a motion by the state involving Copeland's refusal to testify. Since no defendant in this case had a right to be present on June 10th in Chambers meeting with Copeland and his counsel regarding his contempt proceedings against Copeland, the fact of the meeting provides no ground for me. All right, so this is what the real part that needs to be argued here, right? No, excuse me. This is what needs to be argued. No defendant on trial in this case had or has any legal interest in or any standing to be involved in this. Now, somebody help me out, all right? And y'all, maybe somebody else knows this and could tell me what in the world Love is talking about when she says that. What's going on, Rock Boy? How is it possible that a contempt that happened in a trial is somehow unrelated to the trial where the contempt happened? Because that's what Attorney Love has said a bunch of times in court, and that's what she keeps on saying, and that's what she put in this recusal response, that somehow the contempt and somehow them bringing him to a back room with a judge and prosecutors to tell him, this is why you should be testifying against these people, and here's the rules, and this is how you get out. The only way you get out of this is by testifying against these people. How is she using any law to separate that contempt from this trial? First of all, we already know that the contempt is not separate from this trial because the precedent has already been set. When Judge Glanville held Brian Steele in contempt, right? Brian Steele put in a motion with the appeals court to appeal the contempt, right? The appeals court was superseded by the Georgia Supreme Court, and they said, we are taking that contempt order. Why is the Supreme Court taking the contempt order? They put out the information. They said, we have to take it because that contempt came from a trial that involves a murder. Any trial involving a murder, the appeals come straight to us, right? The Supreme Court didn't say, oh, no, that's a separate thing. That contempt hearing, that's separate. That doesn't have anything to do with the original trial. Literally, this just happened like a month ago, right? So if the Supreme Court already said there is no disconnect between contempt in a trial and the trial itself, why is Love pretty much saying that her word and her interpretation of this Georgia law is better, or she has a better understanding of it than the Supreme Court, who just made a determination on this exact type of thing within the last 45 days? That's what I'm trying to really understand. What is Love talking about? That meeting, that ex parte meeting where y'all are supposedly, it's only about the contempt and him understanding what type of contempt he's being held in, understanding his immunity order, is not a separate matter from this YSL RICO case. It's not a separate thing. Literally, the Supreme Court just ruled on it in this same exact case. So, or not that, they ruled on it because they said the appeals court can't handle this. This is a Supreme Court matter because it's related to a murder trial. Meaning these things are together. This contempt is part of that. So, Love, I don't, and let's just say that wasn't the case. Let's say the Supreme Court didn't say that. Let's just look at the contents of that meeting via the transcript. Pretty much the entire time in the meeting, they are talking about this trial. They're talking about what's happening in this trial, trying to compel somebody to testify in this trial. That's what the entire meeting is about. Y'all held him in contempt, or the judge held him in contempt. That's fine. But the 24-5-507 is not part of the contempt. The contempt is a result of him not following 24-5-507. 24-5-507 is literally a ruling that came from this trial, right? So that means that whole meeting wasn't just about contempt. That meeting was about him testifying in this trial. So, Love, I think that was probably one of the worst responses to a recusal that's probably ever happened, because everything about it points to you not being correct. And it doesn't even, I'm not even a lawyer. If a non-lawyer can see how bad this is and can point to a bunch of other incidents where that wasn't the case coming from the Supreme Court of Georgia, what do you think a judge is going to look at that and say, what are you talking about? That don't even make sense. Let me go back and read some of these comments to see what y'all are saying about this here. Y'all been commenting a lot. Let me see. Okay, can you make that bigger was the last thing I read. Palm said, any ruling made previously can only come up on appeal minus the recusal. Okay. Esquire said, people say it how they want, though, so you're good. Yeah, them Latin words get me sometimes. Federal 6 said, that means there's precedent to go off. Trucking getting it. Hit the like button, y'all. Yeah, shout out. Hit the like button, please, guys. Okay. Palm said, ask for an extension isn't usually, bro. I don't know exactly what you responded to right there. Esquire, that's what I thought. Why didn't one of the younger prosecutors do the first draft and Love review it and file it? Right. What you say said they've been practicing these habits for a while without prejudice. That's facts. Because they do it to a lot of people that don't have Brian Still as their lawyer. They do it every day. Terry said late response should be tossed. What you say says special privilege. They said Krause is in a wheelchair. What that mean? Oh, C. Brooks said Alec wasn't a Rico. Enough said. It wasn't a Rico, but the conversation, the connection is not really about the type of trial. The connection is about the prosecution withholding evidence. That's what the conversation is really about in these two cases. Pepe Love said it's not improper to donate money to a judge or any campaign official. No, it's not that it's improper. It's an appearance of conflict. And Georgia lawyers, and specifically judges inside of Fulton County, have made rulings to recuse people based on the appearance of conflict. This literally is part of the Donald Trump, Michael Roman, Ashley Merchant, Fonnie Willis, Nathan Wade whole thing. They were recused for the appearance, or Nathan Wade was recused for the appearance of conflict. It didn't even have to be a real conflict of interest. And it wasn't determined to be a conflict of interest. It's an appearance of it. So that's that. And another judge also. I'm going to get that information for you. The real dreadlock boy, money and celebrity bought Alec justice. Yeah. Palm Steele's motion was for the internet. It was petty, but lacked real law-breaking facts, real repetitive. Yeah, that's why, it was a lot of pages. He was just really listing everything that happened throughout the trial, Hippies to the real, but Thug has celebrity and money too. It should be the same. K-Way, what up, people just tapping in? What's going on, K-Way? Palm said pale skin bought him justice. Facts. That's why I said they never wanted to prosecute Alec Baldwin anyway. They was going back and forth. If y'all remember, this happened years ago. They was going back and forth, dropping case, then picking it back up and all types of stuff. So they never wanted to prosecute him. K-Way said Love lied through the whole response. Facts. Fiddle Didi said the defense has created so much chaos. It's like teaching losing control of the class. It's like a teacher losing control of the classroom. It's a mess. Facts. Palm says she didn't lie. It's just her biased perspective. Okay. Pepe Love. Krause is a judge, not the prosecutor. DA Love response lacked relevance. At least she showed support for Glanville. Oh, they call him Granville. I don't know. His name is Glanville, though. Palm, she could have replied with a smiley emoji. She knows nothing is changing. That's facts. Now, that's the real facts right there, Palms. The reason that Attorney Love responded this way is because they're all working together and she knows that they're not about to recuse Glanville. Glanville is going to have to step down himself due to stress because he don't want to deal with it no more. I don't see this judge recusing him just based on the fact that they gave the state 7 days to do something. The state didn't do it, and then they just gave him another 2 days. Let's see. Let me see. K-Way, she basically told the judge that Woody shouldn't be an important witness to the defense. Tyree said, you think the state response is sufficient enough for the judge to deny recusal of Glanville? I don't think the recusal of Glanville has anything to do with that, with the response from the state, honestly. K-Way, question is, why haven't Glanville submitted his response? Yeah, he is supposed to, huh? He is. I don't know if Glanville has to do it through Krause though. I think Glanville just has to submit it to the court, to the state. I don't remember. Let's see. Hippie Easter. If they all in it together, it doesn't matter what love. Facts. Rock Boys, what up though? Esquire, Love ain't good with witnesses though. She's not. She is rough with them, and they don't like her much. Jay Carter said, no, the prosecutors are playing dirty. Miss Shante said, this reminds me of the movie Your Honor so much. Yeah, the TV show or the show. Hip Easter. In the Baldwin trial, most of the prosecution team quit, including the other woman who quit this morning. If Hilton wants a career, she needs to remove herself from this mess. I think Hilton is too invested to remove herself. She's not going to remove herself because her name is already on it. So she needs some type of victory. Plus, Hilton is the main one prosecuting all the other guys. So she needs a victory. She can't. Hilton is not disconnected from this at all. Love is leading it, but Hilton is like driving it for real. Hilton going to pull a Nino Brown if she about to lose her bar card. Esquire, that's some BS. Val Powell, it's the same way she attempted to treat Miss Bennett's contempt separate from the trial and was completely blocking the defense from attempting to help her. Yep. Hippies to go Astros, another win. Shout out. I think Did the Indiana Fever just beat the Phoenix Mercury also tonight? Caitlin Clark was going off. I saw some highlights right before I got on here. I think Steele was giving Krause the cliff notes. She didn't have enough time to catch up. Right. Esquire, Steele's motion was very well done. Legal writing is repetitive generally. Yeah.